going through the program in custody, but it means getting through the aftercare and everything else successfully. If you do all of that, then you're still on these deferred probations. You still don't have felony convictions on your record. This is, again, the opportunity of your lifetime right now for you to make the changes and do the right thing. If you don't, and you come back in here, then you are going to end up with 2 felony convictions, and you're going to end up going to TDC for up to 10 years in one case and state jail prison for up to 2 in that case. Do you understand?
Yes, ma'am.
Let me explain something else. I am also now making it a condition of your probation that you treat the staff and the correctional officers at our jail and at Safety and wherever you are with respect, and you follow all of the rules when you're incarcerated. That means if I get another incident report before you get to state jail, before you get to Safety, it's already a violation of your probation. They're going to let me know, and you're never even going to make it to Safety. You're going to be right back in here and looking at going to prison. Do you understand?
Yes, ma'am.
So the way you're talking to them at our jail, you cannot keep doing that. You cannot keep arguing. You can't keep fighting. You can't keep saying, F that, I don't care, things like that. Okay. And you're looking at me like you're confused, that maybe you didn't do these things, but this is what I have. Every time you act up, every time you tell someone, if you're going to send me out, just do it, F that, or whatever it is, that's disrespectful.
Yes, ma'am.
All right. They're just trying to go there and do their job every day. Hopefully someday that's what you want to do. Get out of jail, go to work, and not have somebody treating you like this when you're at your job. Right?
Yes, ma'am.
All right. So you'll sign some paperwork today for Safety, and okay, I guess just obviously by what I'm looking at, that seems, am I looking at the right thing? Dakota Chapman? The first violation is that he committed the offense of murder?
That has been abandoned.
That was not.
Yeah, go.
Okay,
I'm sorry.
thank
Maybe
you.
we should have started with that.
We're just gonna go to Safety and,
No.
okay,
That
so,
was done in December. Here's.
let's do this. I'd like to go ahead and go through the motions, get pleas of true or not true to the remaining counts. And then obviously if you guys have an agreement, we'll look at that, but I think I want to go through and have those pleas on here.
And that came at the recommendation of his supervisor, who
Okay.
I'm sure has much more information for the court as well.
That's good. Thank you. If you want to print this section, I'll just do the first one on here. All right. Will he waive the formal reading of the motion in each case? Mr. Chapman, in clause number 23, DCCR 1077, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation May 6th of 2024 for the offense of evading arrest or detention with the use of a vehicle, a 3rd-degree felony, and that was a 5-year deferred probation. Is that correct?
Yes, ma'am.
And then in clause number 23, DCCR 1078, I also have a motion to revoke your unadjudicated probation. This shows that you were placed on probation May 6th of 2024 for the offense of accident involving injury, a state jail felony, and that was a 5-year deferred probation. Is that also correct?
Yes, ma'am.
And so the state is going to abandon each case count 1, correct?
Correct, Judge, based on the comments of the grand jury.
So, Mr. Chapman, in each case, the motions allege you violated your probation. Count 2 in each case alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true?
True.
Count 3 in each case alleges that you provided a urine sample March 12th of 2025 that tested positive for cocaine. Is that true or not true? Count 4 alleges that you provided a sample September 3rd of 2025 that tested positive for methamphetamines and amphetamines. Is that true?
True.
Count 5 in each case alleges that you admitted to your probation officer to using the illegal drug ecstasy December 3rd of 2025. Is that true or not
True.
true? I'm sorry. Count 6 alleges in each case that you were at a location other than your residence at approximately 1:53 a.m. December 21st of 2025. And is that true or not true?
True.
Count 7 in each case alleges that you failed to successfully complete the defensive driving course as ordered. Is that true or not true?
True.
Count 8 in each case alleges that you are behind in your court assessed fees. And is that true or not true?
True.
Did you enter your pleas of true in each case to counts 2 through 8 freely and voluntarily? And did you plead true to those counts because they're actually true? So it's my understanding, Mr. Chapman, that the recommendation is that I continue your probation and order you to enter and successfully complete the special needs safety. Is that your understanding?
Yes.
Is there any reason to get any type of pre-sentence report or update?
Only at the court's discretion, Judge. The officer, Ms. Valier, has already prepared for the court the continuation and modification of that special condition if the court would like that to be signed off on today. Otherwise, I'm sure she'd be happy to do a quick update.
If it's her recommendation, we'll just go ahead and go forward.
I
So
think that was, I'm sorry to interrupt, I think that was done prior to count 1 that we see, which obviously caught everyone's attention and just took that immediately off the table. But
Right.
since that was no bill, I think that's when she finds herself back in the same position.
So, Mr. Chapman, you're getting your second chance today.
Yes, ma'am.
There's not going to be a third. Okay. You need to take advantage of this. I don't know what happened. The night of December 21st to 25, obviously it was no bill as far as the offense, but you were clearly somewhere you shouldn't have been doing some things you shouldn't have been doing, right?
Yes.
If you had been home during curfew, you never would have been charged with anything. There wouldn't have been any issue of whether or not you did anything, right?
Yes, ma'am.
So I want to make sure you understand if I go along with this and send you to safety, you're going to get some tools so that you can hopefully stop using drugs, do the right thing, live your life like the rest of us and not end up in prison. Do you understand all that?
Yes, ma'am.
All right. So at this time in each of your cases,
I don't know how the court would feel about an extension, Judge, based on the age.
yeah. So at least in the evading.
Okay.
I'm going to do that. We're going to talk a little about the jail incident reports as well in just a
Yes,
minute.
ma'am.
So I'm going to find in each of your cases that you entered your pleas of true to counts 2 through 8 freely and voluntarily. Find those counts true, find sufficient evidence in each of your cases to revoke your probation. But I'm going to go along with this agreement today, and I'm going to continue your probation in each of your cases. In clause number 23 DCCR 1077, I am going to extend your probation by 2 years. And I'm going to order in each of your cases that you enter and successfully complete safety. That obviously means, I think that's it as far as adding the condition. So add 2 years in the one case and the condition with regard to being successful and not being disrespectful.
Yes,
Okay.
ma'am.
All right. Good luck to you. You can go back with the bailiff. And here's that. Derek Corbin.
Judge, on this one that I previously was evaluated competency. He is competent. I got a new offer from the state on him. I was gonna ask him, let me sit him 1 week, so I got some family to talk to him. He's a little better, but it's still some issue.
We'll reset Derek Corbin 1 week.
1 week.
Velma Gilbert.
Thelma Gilbert.
No, I didn't. I still need to, I'm gonna go through all those cases.
Okay.
Yeah. That's a lot. That's good.
Good morning. Are you Thelma Gilbert?
Yes, ma'am.
And Ms. Gilbert, in cause number 26, DCCR 0502 is charged with credit debit card abuse. 26, DCCR 0503 charged with burglary of a habitation. 0504 charged with credit debit card abuse. 0505 charged with credit or debit card abuse. 0506 charged with credit or debit card abuse. 0507 charged with fraudulent use or possession of identifying information. And 0508 charged with theft of property. And what is the announcement?
Judge, I've gone through most of these cases. I've talked to Ms. Gilbert about it. Also about her other situation yesterday is going on. She is currently on parole. So there's a parole hold on dealing with her as well. I just need to finish up going through a little of some of that stuff. I haven't been on it that long,
No.
but and considering that the offer will be something substantial as far as
Sure.
the resolution, I just need a little time with it.
All right, so I'm gonna just do a normal reset. That'll give Mr. Lewis time to get through everything and all of the discovery and all of your cases, go through that with you, and then we'll get an announcement at the next court date.
Yes, ma'am.
All right, you can go back with the bailiff.
Thank you.
So these are two different people, Tan Van Pham and Van Tam Pham,
Yeah,
and you've got both of them?
It's the same person. It's the same person, and that's the issue that I'm having. So
Okay,
we did have the same.
Previously, there was a Thai Van Pham with similar cases.
okay.
He has pled and been sentenced and on his way.
So all of these, 1, 2, 3,
Seven.
4, 5, 6, 7 cases are the same person?
Same person.
Okay, Tan Van Pham, please.
Bam.
And for a while, we had them both on the same dockets, which
And I was previously appointed on the.
Some of
first.
them will just have the name flip, Van Pan instead of Tan Pan. Okay. Good morning.
Good morning, ma'am.
You are Tan Van Pham,
Yes, ma'am.
and Mr. Pham has 7 cases, all charged with theft of property with previous convictions. And what is the announcement?
Judge, on this situation, he has several cases that he's charged with. We had another defendant that very similar situation, same name, that was on the same docket at one point. And it's questionable if some of these or the other person, to be honest with you, they're both actually from the same area of Port Arthur. And so I'm trying to go through all the surveillance just to make sure who's who.
Okay,
So I would at least like.
and it looks like some we've got 3 different kind of indictment
Right.
timeframes on these, some not. So Mr. Pham, I'm going to reset your case one more time to give Mr. Lewis time to go through all of that. He'll be out there to visit with you, and we'll get an announcement at the next court date.
Yes,
All right, you can go back with the
She
bailiff.
said she want to give me a network.
yeah, we're getting reported.
You don't know why they hold me here. I didn't do nothing.
Well, Mr. Lewis will talk to you about that, okay?
Okay, go back.
What about April Smith?
That's the one that was reset from last week, Judge, with the,
Sentencing on
Safety.
April Smith?
right.
What was that for?
Her husband to talk to her about the safety.
We had asked the
Bring-
court to consider safety based on her priors. You didn't know if you wanted to do that last week.
Uh-huh.
You allowed her husband to go out and talk with her about how much she really needs safety for her children, but of course, we ultimately left it to your decision.
So what about the 2 new cases?
Well, our offer, Judge, just in
April Smith coming?
in hindsight was that we would kind of wait to see what the court's position was with respect to safety. Those were actually on the grand jury cart at last docket. I have since been assigned them, and so if we need to plead to one or both of them, we can do that. an expedite her to safety if we go that direction. Otherwise, the offer was to first take the 2 year stay jail on the probation case and to plead to at least one of those offenses so that there's the priors in her history.
Right. I think when the pleas were done, those were abandoned at that time because they haven't been presented yet.
I don't even know that we had them in the office. They have since been indicted last week, and I now have them and can prove them up by next week if the court would like.
Well, what's your client's position with regard to that offer of safety?
Oh, she definitely wants to do the safety.
Then I want pleas of everything today, if I'm gonna do that. She's got to take responsibility for those new cases, if y'all want to get the paperwork done for whatever agreement you've reached on those. But I mean, I don't think dismissals is appropriate.
No,
In
we,
the new ones.
and that wasn't the plan
Okay.
necessarily. When we didn't have them,
Yeah.
it was, let's not hold her up for safety,
Sure.
but now that we have a cause number to plead to. we-
Yeah, we need to get them all taken care of today. All right?
We'll take care of that.
Yes, sir. I'll hold it.
Thanks.
And then you've got Jordan Thomas.
What was Judge Thompson?
Jordan Thomas.
Jordan Thompson.
Good morning.
Jordan.
Good morning. Been waiting all morning.
I know.
Morning, Tommy.
And Judge, this is when I was retained right during that transition when Ms. French took over those cases. So we've had a little time to talk, but not much.
Good morning. Are you Jordan Thomas?
Yes, ma'am.
And this is cause numbers 24 DCCR 0487. Mr. Thomas is charged with sexual assault of a child, and 24 DCCR 2178 charged with aggravated assault with a deadly weapon. And Mr. Lewis, what is the announcement?
Judge, this is one I've been previously retained on, or recently.
Yeah, okay, I see that.
Retained on. I got on this case. I've talked to Ms. French a little bit about it. She's reviewed it over the weekend actually and gave me an offer this morning
Okay,
in regards to where you are. I do have discovery. So now I just need to go sit down with
Sure.
Mr. Thomas. So we
okay.
can take-
We'll just do a normal reset, give you plenty of time to go over everything with Mr. Thomas, and we'll get an announcement at the next court date.
Yes, ma'am.
All right, Mr. Thomas, we'll see you at the next court date. And I'm holding April Smith, okay. And then Ms. Brazo.
She's still signing the rejections, no.
Oh, I feel like we've already done. I don't know if she needs to do all those, but I see that she's doing them. Don't get that set.
I have 2-year-old.
Do you? Say, Mr. Rojas, what was I holding for you? Jimmy Couch?
Jimmy Crowe.
If we can reset him, Mr. Couch wants to file a bond reduction.
Okay, I'll reset Mr. Couch.
We don't need.
Judge Meyer.
Reset.
Plaintiff is here today. She's spoken with myself and Mr. Rojas both, and we will be objecting to that bond reduction.
Okay, so we'll take care of it then at that time. Obviously, if there's evidence that would help me, bring whatever witnesses you need. What about Willie Pugh?
Willie Pugh, Judge, if we can reset that, I'm going to file a motion to suppress on that, but that may be dispositive.
All right, we'll reset Mr. Pugh as well.
And Judge, that could probably be just one day, maybe on a non-jury week after a regular docket.
Okay, perfect. Thank you.
Thank you, Judge.
Thank you, Mr. Rojas. So Mr. Gertz had to go to, oh, hi, good morning. I was like, where is he?
If I was
You're standing.
any closer to you, we'd probably be in trouble, right?
That would, right, on Giovanni Coleman.
Yeah, Judge, may I have a few minutes on that?
Yeah, I'll hold it.
Sure.
And then they're working on.
Reset.
I know, I've already gone, so I was his stuff.
So Ms. Palazzo was Beal
David, that was on
Who?
initial rate.
and Giovanni.
Oh, well, let's just,
Yeah.
It's okay, just get the order and I'll sign it and let's go to the court plan. Mm-hmm. Yes, ma'am. Yes, Ms. Delage. Looks like we have Mr. Rojas here. Good morning.
Good morning.
And I was in a hurry, thinking I was late.
Well, I said he's next to the laundry guy, but he doesn't have.
See, Mr. Rojas, you've got Jamon Adams.
Devon Adams.
Morning. Good morning. Are you Jamon Adams?
Yes, ma'am.
This is 26 DCCR 0744. It looks like Mr. Adams is charged with aggravated assault with a deadly weapon, and Mr. Rojas has filed a motion asking that I reduce the bond currently set at 150,000. Is that correct?
That's correct, Your Honor.
Mr. Adams, the best you can, raise your right hand, please, sir. Do you swear?
Okay.
Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead, Mr. Rojas.
Hey, Jim, how old are you?
21,
Where are you originally from?
Houston.
Okay, but when this incident happened, you were living here in town with your dad?
Yes, sir.
And your dad's the victim of this, is complaining witness in this case, right?
Yes, sir.
Okay. How long have you been in jail?
Since April 8th.
And the only other person other than your father that can realistically help you with this is your mom, right?
Yes, sir.
Okay. And your mom, you've talked with her and you've talked to she's unable to make a bond for $150,000.
No, sir.
Okay. Do you own any property that you could sell, a house, a car, a land? Do you have a bank account in your name?
Yes, sir.
Do you know approximately how much money is in that account?
Probably zero, maybe in the negative.
Okay. This is, again, you're 17 years old. This is the very first time you've been arrested, right?
Yes, sir.
Okay. Your mom's gonna help you out with the bond if we can get it lowered and I think maybe an aunt. He said maybe there's an aunt out there that can help her.
Yes.
Okay. Are you married?
No, sir.
Do you have any kids?
No, sir.
Okay, so it's just you.
Just me.
So if you're able to make a bond, like I said, before this, you were living with your dad. What's your plan? If the judge will let you, you want to go live with your mom in Austin?
Yeah, so I will go to Austin. I already have a job lined up for myself. She's holding it down for me right now. She's also working to get her own apartment so that I can go move in with her, start working and continue back on my journey to get back in school.
Okay, and you say get back in school. Was that high school?
No,
Okay, where were you going to college at?
probably did relief from university. It's in San Antonio.
Okay. And once you're able to get this all behind you, that's your plan to get back into college.
Yes.
All right. That's what it's doing.
Just so we're clear, you're 21 years old, right? Not 17. I think that was a misstatement.
Yes.
Okay.
21, yes.
Apologize. Did I say that?
I think you said 17. I know it's an error. I have another question, George.
Okay. Any other witnesses?
No, Judge.
Mr. Nichols, what's the state's position?
Judge, he's accused of breaking into his own home after he'd been kicked out. And when his father tried to push him out the window that he broke in through, he grabbed a knife and stabbed him. I think 150 is appropriate in this situation, Judge.
And for the record, I am taking judicial notice of the court's file. It includes the probable cause affidavit. If you'll give me just a second, let me So you, you said you would be going to Austin if you make bond, no matter what that is, and living with your mom, is that correct?
Yes.
But that she would be getting her own place. Where does she live now?
I believe it's one of those homes where she's pays for that space.
Okay,
I believe the money she's paying there, she can also pay for an apartment. So that's what she's doing while working both jobs.
and what's the job that you would have?
I would have the IHOP job. That's her second job. That's the job that I will be going to.
When's the last time you were in school?
I'm I believe in May of 2024. That's when I left college. Then keep up the $40,000 on my own.
Speak up.
I said I cannot keep up the $40,000 on my own for tuition.
Any history that you can?
Minor juvenile, I think an arrest and a non-suit out of Harris County for burglary, when he was a juvenile, but nothing else, right?
All right, so what I'm going to do, Mr. Adams, I'm going to grant the motion. I'm going to reduce your bond for $100,000. Condition of that bond, if you make it, is going to be that you obviously have absolutely no contact, no communication with David Keys. You will be ordered to wear a GPS monitoring device. You will be allowed to live in Austin with your mom. You would have to get that address before you go to your attorney or to your bondsman. And also obviously not be anywhere near the residence at 1970 Ave Street. You understand?
Yes, ma'am.
No contact and no communication means none. That not sending messages obviously means in person, but it also means sending any type of messages yourself or through anybody else or anything like that. You understand?
Yes, ma'am. I have no intentions.
And we'll reset it for an announcement. All right, you can go back with the bailiff.
Thank you.
Thank you.
Thank you.
See Cody Arnold. Mr. Rojas.
I don't have the attachment that I'll be to this afternoon.
Okay, thank you. Good morning. Are you Cody Arnold?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Here we are.
Mr. Arnold, in cause number 26 DCCR 0488, you're charged with the third-degree felony offense of harassment of a public servant from January 30th January 30th of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes, ma'am.
You fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number one,
No objection.
it's admitted. Is there any evidence that Mr. Arnold is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the third-degree felony offense of harassment of a public servant. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows this was an agreement that I followed, so you did waive your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Do you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts? You can talk to Mr. Rojas. All right, good luck to you, sir. You go back with the bailiff.
Yeah, go.
Bethany Batten.
That's Bethany.
My judge.
Good morning.
Hey, do you know if it's credit anytime somebody can get to the hospital? I'm not opposed. I think she does. Well, she should have it. I can, you know, she did when.
Good morning. You're Bethany Batten?
Yes, ma'am.
And this is cause number 24, DCCR 2349. I am going to take judicial notice of the court's file. I think we've already gone through this, but just to make sure the record clear, Ms. Batten was previously found not competent to stand trial, sent to the John Dunn Behavioral Science Center for Competency Restoration, was sent back here. It looks like we got a report April 3rd of 2026 that Ms. Batten was now currently competent to stand trial. Any other issues with regard to competency?
No, Your Honor, not from the state.
All right, then I'll make that finding that she is competent to stand trial. Will she waive the formal reading of the indictment?
She will, Your Honor.
Ms. Batten, you're charged with the third-degree felony offense of assault on a security officer, and that's from November 14th of 2024. And how do you plead to that charge?
Guilty, ma'am.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And you understand if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation,
Yes.
exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. All right, Ms. Batten, I'm going to find that you entered your plea of guilty freely and voluntarily. I find again that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of assault on a security officer. Sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, ma'am. You can go back to the bailiff. Jaden Brantley.
Just, I don't know if you want to bring him out. We can. His grandmother's trying to give me some medical records.
Okay, let's,
Give a reset on it if I can.
does he know that? I guess.
He knows, yes, ma'am.
We'll just reset. We'll reset Mr. Brantley. Mr. Nichols, I'm gonna do a normal reset so that Mr. Rojas can get some information from the family. Jimmy Couch,
Can we hold Mr. Couch, Judge? Ms.
Yeah.
Campino and I need to talk about that.
sure. Reagan Hulsman,
Reagan, Gilson. Reagan.
We need some direction on this.
I agree with Mr. Willhouse on that, Judge. It's a little, that evaluation, I have some questions about the evaluation.
Reagan, is there a Reagan?
well, it didn't really say.
It doesn't say, yeah, page
Okay.
10,
Well,
A recommendation.
not one of you guys,
Oh,
I mean,
hey,
did either of you try to reach out to the doctor to ask her?
I have not, Judge.
Okay, so I'm gonna, let's reset Ms. Hulsman. If you'll reach out to Dr. Grimsley
Okay.
and just ask if, I mean, this looks like just a regular psychological evaluation, which is what it's titled instead of a sanity evaluation. And so let's get with her if you would, and we'll make a notation, but if you'll call and find out about the actual sanity evaluation, if she's able to do that. If for some reason she's not, we can get, one of the other doctors to get that done pretty quickly. All right? Okay, you can go back with the bailiff. Byron Morris,
They didn't bring him over, Judge. He wasn't on the list to bring over.
okay? It's not here. Okay? All right, so let's just reset him to next week.
Can I get 2 weeks on that, Judge? I'm probably not gonna be here next week.
Sure. 2 weeks. Willie Pugh,
We can hold on that one. I need to talk to some small people about that.
sure. And then what about Kashonda Riley?
That's gonna be a plea.
Let's get
please.
Kashonda Riley, please.
Riley.
There, a third one?
Oh, it's not gonna help. Hey.
Good morning. Are you Kashonda Renee Riley? Yes, ma'am. Will your client waive a formal reading of the indictments and the motion?
She will, Your Honor.
Ms. Riley, in cause number 26 VCCR 0210, you're charged with a state jail felony offense of theft of property with previous convictions from December 20th of 2025. The indictment alleges that you were previously convicted of theft August 25th of 2017, and then 2 cases on March 1st of 2023. And how do you plead to that charge?
Yes,
And are those prior convictions true?
yes,
Did you enter your plea of guilty and true in this case freely and voluntarily?
yes,
And did you plead guilty because you actually did what they've charged you with?
yes.
Then And clause number 26, DCCR 0211. You're also charged with theft of property with previous convictions, a state jail felony, and this is from November 24th of 2025. It alleges those same prior convictions for theft, and how do you plead to this charge? And again, are those prior convictions true?
Yes.
And you entered your plea of guilty and true freely and voluntarily,
Yes.
and because you actually did what they've charged you with.
Yes.
In each of those cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes.
Do you fully understand them?
Yes.
And you understand if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreements that you've reached in these 2 cases is for a cap of 15 months in the state jail prison, which means if I follow the agreement, I cannot give you more than 15 months. I can give you 15 months. I can give you less. It'll depend on the information that I receive when we come back from sentencing or for sentencing. You have an absolute right to have a jury come in and decide 2 things. The first is to decide if you're guilty or not. And then if that jury finds you guilty, you could leave your punishment up to them. If we go forward this way, you're waiving that and leaving it up to me. And is that what you want to do?
Yes.
State tenders number 1 in each of those cases.
No objection.
It's admitted in each case. Is there any evidence that Ms. Riley is not competent?
No, Your Honor.
All right, ma'am. In each of these cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset both of those cases so that we can get a pre-sentence report done. That'll give me some more information about you and the cases, and then we'll come back later for sentencing.
Yes.
And then we have cause number 24, DCCR 1778. Give me just a second. All right, this shows that you were, this is a motion to revoke your unadjudicated probation. Shows that you were placed on probation April 21st of 2025 for the offense of theft of property with previous convictions, a state jail felony. And that was a 3-year deferred probation. Is that correct?
Yes.
It alleges you violated your probation. Count 1 alleges that you committed the new offense of theft of property with previous convictions December 20th of 2025. And is that true or not true?
Yes, ma'am, it's true.
And then count 2 alleges that you committed the offense of failure to ID a fugitive with intent to give false information on December 20th of 2025. And is that true or not true?
True.
Count 3 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true?
True.
Count 4 alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true?
True.
And then count 5 alleges that you are behind in your court assessed fees. Is that true or not true? Did you enter your pleas of true to counts 1 through 5 freely and voluntarily?
Yes.
And did you plead true to those counts because they're all actually true?
Yes.
I also have here on the tablet, in that case, some documents that have your signature on them that the state's marked as exhibit number 1. Did you also go over these with Mr. Rojas?
Yes. Ma'am.
And you understand if I follow the agreement, which is a cap of 15 months in this case as well, that you'll be waiving or giving up any right to appeal.
Yes.
State tenders number 1.
No objection.
All right, it's admitted. All right, Ms. Riley, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation, but I'm going to hold on that and reset your case for sentencing. Again, I'll get an updated report from probation and then we'll see what we get when we come back. If there's anything that you think is important for me to know, get that information to Mr. Rojas and he'll present it to me on your behalf when you come back. All right.
Judge, a first amended motion was prepared on Friday to be filed. I'm going to
Okay.
hold it since we've reached an agreement on everything and it won't be filed. All it did was add one of the cases she's already pleaded guilty to.
Okay. All right. Thank you. All right. You can go back with the bailiff. Ms. Delage, you've got Heriberto Chavez. Is Ms. Burge here?
We've reached an agreement.
Okay.
And we're waiting for that to go through.
Oh, okay. I'll recall it as
Thank
soon as
you.
it's ready. Thank you. Mr. Lewis, you've got DeJuan Banks.
One by. The one, right?
There's nothing, no paperwork on this one.
No, but on this one. You just be I've been talking to Mr. Mofino about it. Perhaps.
Good morning. Are you DeJuan Banks?
Morning, yes.
This is 25 DCCR 0990. Mr. Banks is charged with injury to a child, elderly, or disabled individual. And what is the announcement?
Judge, I've gotten some contact from some family members who are also family members to the complainant involved. I got that over to Mr. Mofino. We're trying to get that resolved and I get in contact with them. As soon as possible. They're out of state, so it's what's kind of been the difficulty.
Right, this has been. Looks like he's been in custody since October.
It's been a while, Judge. We've had some issues with trying to resolve some CPS issues. Initially, the child has also been replaced multiple. Trying to locate the child without saying too much has been somewhat difficult. I think that there is family that's involved on both sides. We also had a guardhouse issue. We brought him over and since watched the guardhouse. So just that final conversation, if we can some way or how, either via phone or Zoom or something, all of us together, since they're out of state, before we put it on the trial docket, once we get to the trial docket, it's gonna be up in the air, just depending on what I'm able to do with respect to witnesses, et cetera. I certainly understand his having been in custody because I don't feel like the child is here locally and Mr. Lewis wants to approach him on the issue. I don't.
So but let's do this. I'm going to reset it. This will be the final reset for an announcement, whatever you guys need to figure out between now and then. If it's going to go in the trial docket, if you file a motion for a bond reduction, I'll take a look at it. But it's definitely time to get something moving. I understand the issues that you guys have had, but it's time to do something. So this will be the last reset for an announcement.
No.
Right? You can go back with the bailiff.
Thank you.
Mr. Parker, you have Jeremy Alexander.
Jeremy Alexander.
He didn't like me. Because of enhancement. Does it make sense? Yeah.
Good morning. Are you Jeremy Germain Alexander?
Yes.
And Mr. Alexander, this is cause number 26 DCCR 0178. You're charged with the third-degree felony offense of injury to an elderly individual from November 17th of 2025. Your indictment alleges that you were previously convicted of burglary of a habitation, a second-degree felony, May 10th of 2021. What that means, sir, is that if you go to trial and you're found guilty in this offense, then the range of punishment, if that prior conviction is true, would be enhanced to a second degree felony, which means your minimum punishment would be 2 years up to 20 years in prison. Do you understand? I need you to answer out loud for the record, please. And I have here on the tablet a plea bargain rejection that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for an 8-year term in prison. You have every right to reject that offer and have your case set for trial. I want to make sure you understand what the possible consequences are if you go to trial, what your options are today if you wanted to plead guilty.
Yes, ma'am.
You understand all of that?
Yes, ma'am.
You want to reject that offer and have your case set for trial.
Yes, ma'am.
We'll get that done. Mr. Smith, is there any reason to believe that there would be a change in that offer? You've got everything as far as discovery. So I want to make sure you understand, Mr. Alexander, that after today, I'll be accepting this offer unless new evidence comes up that the attorneys don't know about. You understand?
Yes, ma'am.
All right, and so, Mr. Alexander, Mr. Parker's been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you?
That's fine.
All right, so Mr. Parker, you're released. Mr. Alexander, someone will be appointed today. They should be out to see you very soon to begin preparation for trial.
Thank you.
All right, you can go back with the bailiff. Edward Godfrey.
Nothing like that back there. I mean, today.
Brief time out.
Her throat's gonna be so crazy.
I think I wrote fast.
Good morning. Are you Edward Godfrey III? And will your client waive the formal reading of the indictment?
No, Your Honor.
Mr. Godfrey, in cause number 26 DCCR 0383, you're charged with the third-degree felony offense of assault, family violence, by impeding breath or circulation from February 6th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please.
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them?
No.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for an 8-year deferred probation. Is that right? Is that right?
I wrote it at 8, but
That was the original, but it was a 6.
I had it 6. I just
Should be 6.
read it wrong. It's
Okay,
6.
so with y'all's permission, can I change this
Yeah.
punishment recommendation? So it looks like the agreement is for a 6-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
No.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Godfrey is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back for sentencing at a later date. Is there juvenile history? He was certified, you were certified as an adult in this case? How old are you?
He's 17.
You're 17, okay.
I don't show any histories.
I just trying to figure out why he's in Crane.
How long you been 17?
Since November. Okay, so you were 17 when this was committed, but they've got to keep you separated. So you won't be 18 until this November. I am going to leave the bond the way it is. I want to see that pre-sentence report based on this age and the nature of the offense and make sure there's everything in place and there's nothing else that we need to do to make sure Mr. Godfrey is successful. All right, you go back with the bailiff. We'll see you back at sentencing. Charles Hairston.
Paul, Eric,
He has a case like out of Van Sant County. This guy's got a master's. He says he didn't dare. He has a problem is he wants to bond out, but he has a bond in the Van Sant County for 300,000. Sorry. What he's trying to, I told him to put bond. He's it's 15.
Good morning, sir. Are you Charles Hairston II?
Yes, ma'am.
And Mr. Hairston, in cause number 24 DCCR 2426, you're charged with a third-degree felony offense of theft of property from November 18th of 2024. And what that means in that case, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
That's right.
And then in cause number 24 DCCR 2427, you're charged with a state jail felony offense of credit or debit card abuse from November 13th of 2024. And what that means, if you're found guilty in that case, is that the range of punishment would be between 6 months and up to 2 years in the state jail prison. Do you understand?
Yes, ma'am.
In each of those cases, I have here on the tablet some plea bargain rejections that you've signed with Mr. Parker. It looks like the district attorney's office has made an offer in the theft of property case for a 10-year deferred probation with restitution. And then in that credit debit card abuse, a 5-year deferred probation. You have every right to reject those offers and have your cases set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to plead guilty. Do you understand all of that?
Yes, ma'am.
And do you want to reject those offers and have your cases set for trial?
Yes.
All right, we'll get them set for trial. And Mr. Hairston, Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and I can appoint a new attorney today who could begin preparation for trial a little quicker. Is that okay with you?
Yes.
All right, Mr. Parker, you're released. Mr. Hairston, we will appoint someone today. They should be out to see you very soon to begin preparation for trial.
Judge, I would say he's talked to me about a bond reduction in these cases. I've explained to him, I think the bonds are probably appropriate. But he's trying to bond out. But there's another case out of Van Sant County and the bond's like, I don't know what the charges are, but it's like $300,000. I told him that this court had no control over anything there.
No, I can't do anything with those bonds. When your new attorney comes to visit you, if they want to file a motion for me to try to reduce these, I'll take a look at it at that point. But I can't do anything that has to do with any other county. All right. Okay. You can go back with the bailiff. Tamara Henry.
Tamara Henry,
Hey, why did they wait so long to file?
It was November.
Good morning. Are you Tamara Henry? And Mr. Parker, will your client waive the formal reading of the motions in each case?
Yes, and they're both the same type charge and the same violations, Judge.
Thank you. Ms. Henry, in cause number 14-19449, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 4th of 2016 for the offense of aggravated robbery, a first-degree felony, and that was a 10-year deferred probation. Is that correct?
yes, ma'am.
And then in cause number 14-19-624, I also have a motion to revoke your unadjudicated probation. It shows you were placed on probation January 4th of 2016 for aggravated robbery also, and that was also a 10-year deferred probation. Is that correct?
Yes, ma'am.
Each of these motions allege that you have violated your probation. Count 1 in each motion alleges that you committed the new offense of theft of property on September 24th, 2024 in Fort Bend County. And is that true or not true?
True.
Count 2 in each case alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true? Count 3 alleges that you provided a urine sample October 19th of 2021 that tested positive for marijuana in Harris County. Is that true or not true? Count 4 alleges that you provided a urine sample November 30th of 2021 that tested positive for marijuana. Is that true or not true?
True.
Count 5 alleges that you provided a urine sample that tested positive for marijuana March 14th of 2022. And is that true or not true?
Judge, if it's all right with the board, we can stop there since we have an agreement.
I just don't understand why this went on for so.
It was a Harris County supervision, and it looks like they didn't send anything over until after she had fled on the
Yeah, she was actually,
cases.
she was actually out of jail when they filed the motion. They filed the motion until November.
Okay. You enter your pleas of true to counts 1 through 5 freely and voluntarily.
Yes, sir.
And did you plead true to those because they're actually true?
Sir.
In each of those cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, Your
Do you fully understand them?
Yes, sir.
And do you understand if I follow the agreements that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, sir.
State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Ms. Henry is not competent?
No, Your Honor.
All right, Ms. Henry, in each of your cases, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence in each case to find you guilty. And at this time, in cause number 14-19-449, find you guilty of aggravated robbery. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative finding of a deadly weapon in that case. And then in cause number 14-19-624, also find sufficient evidence to find you guilty, and at this time find you guilty of aggravated robbery. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative finding of a deadly weapon in that case also. These cases will run concurrently, which means together at the same time. I've handed you the trial court certification in each of those cases that shows that these were agreements that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, ma'am. You can go back with the bailiff.
Thank you, Your Honor.
Thank you.
Guys. Wow. Well, you probably had trouble making the case. Originally.
I think he went away for a while. He went away for a while. She was driving. Would have had trouble tracking out complaining, so that's something.
Right, that's what I'm saying.
Darrell Lee.
Lee. Darrell Lee.
Did you have a good weekend, Judge?
I did. How about you?
I didn't behave very good, yes.
It happens.
Yeah. That's it. I didn't do much of anything yesterday. Yes, recent. Yeah, I'm doing rejection.
The victim is here and she went up, she's doing that and negative prosecution.
Camera down right now.
Y'all can leave the courtroom. Leave the courtroom.
Our camera point.
Go.
Leave the courtroom.
Oh,
I did a rejection, but I don't know if you want to just reset it. I don't.
Why don't we do this? Why don't we, if there's a, sir, pay attention here.
Yes, ma'am.
You're Jarrell Lee?
Yes, ma'am.
All right, and so it sounds like there's some information that is coming today
Right.
from the complaining witness. And so what I'm going to do is reset the case for 2 weeks instead of going through a plea bargain rejection. Give Mr. Smith some time to go through that and see if you want to do something or not with regard to that, and then we'll come back in 2 weeks and see. All right?
Yes.
You go back with the bailiff.
Fine.
Yeah, I'll delete it. I got it.
I don't want to talk to her. Talk to her in the, this is like, she, the system says she's not.
Again.
See, Ms. DeLage, are you ready on Heriberto Chavez?
What's
Ms. Chavez, Heriberto Chavez. Good morning, ma'am. Would you please raise your right hand? Do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English?
Yes.
Thank you, ma'am. How are you?
Excited.
Congratulations. You had
Thank
a graduate I saw.
Thank you.
That's awesome.
Let's talk about that.
With a promising future.
Right kid.
All right, sir, are you Heriberto Chavez?
Yeah.
Yes.
And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mm-hmm. I do. Okay. Yeah. I need the date of it. And if it was just one. Yeah, we'll have to figure out some kind of little, we need maybe a little. Oh, good. Okay, that's good enough. All right, Mr. Chavez, in cause number 25, DCCR 0559, you're charged with a third-degree felony offense of deadly conduct discharging a firearm from May 8th of 2025. And how do you plead to that charge? Guilty or not guilty?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Ms. DeLage with an interpreter?
Yes.
Do you fully understand them?
Yes.
And do you understand if I followed the agreement that you made with the district attorney that you'll be waiving your right to appeal?
Yes, that's fine.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Chavez is not competent?
No, Your Honor.
Mr. Chavez, do you also understand if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
I understand.
All right, then at this time, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of deadly conduct. Sentence you in accordance with your agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am also making a finding that there was a failure to appear in a bond forfeiture September 16th of 2025. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition.
Diciendo que no puede tener en posesión ninguna arma, ni fuego, ni municiones.
Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition.
No poder tener un arma, ni poder tener munición bajo la ley de Texas, puede leerlo enfrente y atrás. Si no entiende algo, le puede hacer la pregunta solo.
And the admonishment I handed you is in Spanish. You need to make sure and read it carefully.
Léalo bien.
If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or how long that lasts, you can talk with Ms. DeLoach.
Puede hablar con su abogado. Okay.
All right, good luck to you, sir. And go back with the bailiff. Thank you, Ms. Bursch.
Thank you, Judge. Muchas gracias.
Thank you, Judge. Thank you, ma'am. Mr. Lewis, you have Dakota Chapman.
I'll leave you next time.
Is there no paperwork on this one?
We do have an agreement together on this one for the safety.
Good morning. I see 3. Did y'all do 4? There's 4. Is there another? Did you?
This is watch out with other students. We're not going to this. We can indicate
All right, sir, you're trailing Hill?
Yes, ma'am.
And Mr. Hill, in cause number 24, DCCR 1500, you're charged with obstruction or retaliation, which is a 3rd-degree felony from June 2nd of 2024. What that means is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
Yeah.
And then in cause number 24, DCCR 1614, you're charged with a 2nd-degree felony offense of aggravated assault with a deadly weapon. That's from July 15th of 2024. And what that means in that case is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand?
I was notified.
I'm sorry.
I was notified, yes, ma'am.
Okay, I just need to make sure you understand, just yes or no, okay? Cause number 24, DCCR 1615, you're charged with aggravated robbery from July 15th of 2024. That's a 1st-degree felony offense, which means if you go to trial and you're found guilty, the range of punishment is between 5 years and up to 99 years or life. Do you understand?
Yes, ma'am.
And then finally, in cause number 25, DCCR 0436, you're charged with a 2nd-degree felony offense of burglary of a habitation from June 19th of 2024. That means that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
In all of those cases, I have here on the tablet some documents that you've signed with Ms. Perazzo that shows that the district attorney's office has made offers if you wanted to enter pleas of guilty in your cases for a 15-year cap on the aggravated assault, aggravated robbery, and burglary of a habitation, with a dismissal in the obstruction or retaliation. So that means you would be leaving your punishment up to me in those 3 cases. And if I followed the agreement, I could not give you more than 15 years. I can give you 15 years. I can give you less. It would depend on information that was brought to me at a sentencing hearing. You have every right to reject that and have your cases go to trial and let a jury decide if you're guilty or not and what your punishment is if they find you guilty.
Okay.
Is that what you want to do? Do you want to reject those offers and have a jury decide?
I'd rather reject the offer because I feel like it would be a better choice for me in the process.
Okay. So what I'll do is get your cases set very quickly for trial. Mr. Nichols, what is the state's position with regard to which case or cases would be
Expected to proceed on the ag robbery, Your Honor. It's the same incident as the aggravated assault. I may join them.
Okay,
But
so,
I tend to go forward on that case first.
all right, ag robbery, possibly the same one. From
And
the
I,
same
and I know
name.
that with the age of these cases, even on its first setting, it should expect to be breached, Your Honor. So we'll be
Yes.
ready for trial.
Okay, perfect. Same thing. Obviously I've asked Ms. Perazzo to get up to speed very quickly on these.
Yes.
That first trial setting is likely to be it going. So we need to get these taken care of and Mr. Hill either out of jail or on his way somewhere else.
Yes, ma'am.
All right, okay, we'll set them for trial. You can go back with the bailiff.
Thank you, Your Honor.
Mr. Hill, wait, real quick before you, I do also want to make sure you understand that after today, I will not accept these agreements. So we'll put your case on the trial docket. We'll get it tried very quickly, but you're not going to come back in later and change your mind unless it's to something different than what the offer is today. Do you understand?
Yes, ma'am. I'm trying to get, after paying Mr. Burbank that much money, I was hoping I could have got a better offer in the process.
Well, this is what the offer is. The offer is not going to change. So I want to make sure you understand that holding out till trial or anything like that is not going to get you a better offer.
Yeah,
This is what the offer is. I'm not going to accept it after today. You understand?
21 hearings, yeah.
All right, go back with the bailiff. Need to look at the dates together on that, I think. Get that, then give our jail a break.
In this chaotic courtroom session, a judge spends hours handling nonstop traffic cases, unpaid fines, suspended licenses, and confused defendants while trying to help people avoid even bigger legal problems. The hearing begins with one defendant facing nearly $1,500 in fines connected to traffic violations, registration issues, and insurance problems. Your total is up to $1,536. Instead of immediately threatening jail, the judge surprisingly starts discussing payment plans, community service options, and ways the court might help the man eventually regain his driver's license. We can put you on a payment plan. The judge even explains the court may clear certain license holds before the full balance is paid if the defendant makes substantial payments. We'll give you your clearance before you pay us all off. Only moments later, another defendant appears after reaching a deal with prosecutors that allows a misdemeanor traffic charge to disappear entirely if she simply pays a civil infraction. We're going to dismiss the misdemeanor. The courtroom then shifts into a bizarre discussion about why people continue showing up to court even after cases were already resolved or dismissed elsewhere. Why would you make 2 trips? As the long docket continues, another man appears facing a charge of driving without a valid license while already struggling with unpaid fines in Tennessee. Tennessee is holding me back. The defendant explains he recently found work through a temp agency at a Detroit scrapyard and is trying to slowly fix his license problems. It sounds like your intention is to get your Tennessee license cleared up. Instead of humiliating him, the judge calmly walks him through how to contact the court online, request payment plans, and avoid making the situation worse. Google the 34th District Court. Throughout the hearing, the courtroom repeatedly becomes disorganized with Zoom confusion, missing prosecutors, delayed hearings, and defendants unsure where they are even supposed to stand. Where's the judge at? What begins as a routine traffic docket slowly turns into a chaotic courtroom lesson about unpaid fines, license suspensions, financial hardship, and judges trying to balance accountability with giving struggling defendants a realistic chance to fix their lives. Do you think courts should focus more on payment plans and license recovery instead of increasing fines people already can't afford? Like and subscribe for more real courtroom moments.